Okay then, disciplinary and grievance procedures in Irish employment law. This employment law HR training for small business owners in Ireland is brought to you by Terry Gorry of businessandlegal.ie. Employers have a legal obligation to provide staff with written procedures before dismissal. Otherwise they run the risk of leaving themselves open to claims for either constructive or unfair dismissal. It is good practice, therefore, for employers to follow the Code of Practice issued by the Labour Relations Commission for disciplinary and grievance procedures in the workplace. The presence of such procedures and enforced procedures in the workplace will be of great benefit to the employer if he or she finds himself in a court or before the Rights Commissioner or the Employment Appeals Tribunal or the Labour Court, because it will stand to the employer insofar as the court will accept that you are a legal and ethical employer and are at least doing your best in terms of enforcing proper good practice in relation to discipline and grievances in the workplace. The fundamental principles of good practice in grievance and disciplinary matters basically are that the procedures you have in your workplace should be fair, they should be clear and understandable to your employees, the penalties should be transparent and obvious, and you should also provide an internal appeals mechanism. The penalties then which will be provided for will obviously depend on the particular circumstances. They can include, for example, an oral warning, a written warning, a final written warning, suspension with or without pay, and in cases of misconduct can lead to dismissal. The basic test then to be applied in relation to your procedures to deal with disciplinary and grievance problems or matters in your workplace, the basic test is one of reasonableness. That is, what would a reasonable employer do in the particular circumstances of the case? Less serious issues should provide for an opportunity to improve for the employee to reasonably attainable targets within a realistic time frame. More serious issues then of misconduct can also lead to dismissal without notice. In relation to unfair dismissal or constructive dismissal, an employer's case will be significantly strengthened if he or she can point to good disciplinary and grievance procedures being present and enforced in the workplace. These procedures, though, will need regular review to ensure that you keep pace with changes in legislation, in regulations, and in EU directives. For more information about employment law in general and the various specific topics, you can contact or you can visit businessandlegal.ie. You can call me, Terry, on 086 8121 797, or you can email me with any query that you have at info@businessandlegal.ie. Thank you.